Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Where the heck are we? Well, we are at our fantastic Central Washington location right here in Cle Elum, Washington. Hey, listen, I want to talk to you about a case that comes out of Minnesota, but it has huge national implications, and it deals with those individuals who are in that age of purgatory. You know what I'm talking about, 18, 19, or 20 years old. Oh yeah, you're old enough to do a lot of things, but in some states, you ain't old enough to actually preserve your own life. Minnesota has this crazy scheme where you got to get licensed if you want to carry a firearm, and apparently you got to at least be age 21 before you can do that. Well, there's been a challenge to it, as you probably know, and that challenge was successful. The review of that case just got to the United States Court of Appeals for the 8th Circuit, and guess what? They too agree that this law is total BS and unconstitutional. So today, let's talk about a big ruling that could ultimately have huge national implications. Let's spend a few minutes, geek out for a bit, and talk about one of the biggest rulings that happened this year, and it comes from Minnesota. Okay, America, this is what we're talking about. We're talking about the case of Worth v. Jacobson. It is a case that is now before the 8th Circuit Court of Appeals. It is a challenge to Minnesota Statute 624.714, which of course is this licensing regime that you must go through in order to carry a firearm. And of course, you're not even eligible to get a license to carry a firearm. That means you are not eligible to preserve your own life with your Second Amendment rights until you are age 21. Okay, now understand, this is the big deal here, is that at the trial court level, the trial court summary judgment this thing out in favor of the plaintiffs. They said, hey, this law is unconstitutional. It now comes up for review on the 8th Circuit, and the 8th Circuit has said ditto. Yeah, this law is unconstitutional, and we are going to affirm the summary judgment. As the court put it, the district court granted summary judgment to the plaintiffs, finding the Second Amendment's plain text covered their conduct and that the government did not meet its burden to demonstrate that restricting 18 to 20-year-olds' right to bear handguns in public was consistent with this nation's historical tradition of firearms regulations. Okay, now understand, this is a facial challenge to this statute, and that's a lofty burden here. So essentially, as the court puts it, in effect, the plaintiffs, by asking this court to affirm the grant of the facial challenge, are speaking of a range of people, all those 18 to 20 years old who want to publicly carry a firearm for self-defense. A facial challenge requires the challenger to establish that no set of circumstances exist under which the act would be valid. Okay, so I want you to think about the burden of proof here. Okay, you got to come up with literally an argument that says there is no circumstance under God's green earth here that we can determine that this law would actually be constitutional. And that is exactly what the plaintiffs have done here. Now, this case is brought to us by the Minnesota Gun Owners Caucus, the Second Amendment Foundation, and the Firearms Policy Coalition, which means we're going to put links for all of them down below so you can show them some love. But there were some individual named plaintiffs, those that were under the age of 21. But however, by the time that this case was getting to maturity, all of them were now like retiring age at this point. They had all matured past the age 21. What the plaintiffs did here, kudos to the plaintiffs and the plaintiffs' counsel here. You guys did some fantastic work. Is they got an additional plaintiff added so that they always had a named plaintiff who was under the age of 21. Now, I want you to know that the state of Minnesota tried feverishly, and there are several pages of this memorandum here that talks about this, is that they were saying, oh, they don't have standing anymore. Oh, now the issue is moot. Anything that's similar to what is on the last scene of The Wizard of Oz. Paid no attention to the man behind the curtain. But this move by the plaintiffs, which was brilliant, actually saved the lawsuit. And as the court pointed out, to avoid mootness of this entire case before the last individual plaintiff turned 21, the plaintiffs moved to supplement the record with the affidavit of Joe Knudsen, a 19-year-old Minnesotan seeking a permit to carry, who is a member of all three organizations in order to continue the standing of the organizational plaintiffs. Okay, now, obviously what the state of Minnesota was arguing is that, hey, the Second Amendment doesn't necessarily cover this activity. How could they possibly argue this? Well, this is what I want everyone in Minnesota to be aware of, okay? Minnesota, listen up real carefully. What they argued was 18, 19, and 20-year-olds are not part of the people as contemplated in the Constitution and the Second Amendment. Let me say that again. That means that even though you are of an age where you could vote, you could enlist in the military, you could die for your country, the state of Minnesota believes that you yet have not earned the status of part of being the people. Don't believe me? This is how the court addressed it. Minnesota asserts that ordinary, law-abiding adult citizens that are 18 to 20 years old are not members of the people, and thus the plaintiffs are not protected under the plain text of the Second Amendment. Okay, so again, I want you to remember, you can join the military, you could vote, you could be placed in an adult prison, but the state of Minnesota is arguing that you are not yet part of the people. But fortunately for the young people of Minnesota, there is long-standing precedent which states the following. Ordinary law-abiding citizens that are 18 to 20 years old are members of the people because, 1, they are members of the political community under Heller's political community definition. 2, the people has a fixed definition, though not fixed contents. 3, they are adults. And 4, the Second Amendment does not have a freestanding, extra-textual, dangerous catch-all. So then the state of Minnesota spends pages and pages and pages trying to argue why 18, 19, and 20-year-olds, despite all the responsibility that we're willing to give them, are not part of the people. Ultimately, none of it was persuasive, as the Eighth Circuit has ruled. Importantly, the Second Amendment's plain text does not have an age limit. And it's important to note, because if you take a look at other portions of the Constitution, we have in fact placed age limitations on individuals who can serve in certain positions or who actually enjoy certain rights. And so, as the plaintiffs pointed out here, in the plain text, a 25-year-old age requirement to serve in the House of Representatives and a 30-year-old age requirement to serve in the Senate, asserting in the plain text a 35-year-old age requirement to serve as president. In other words, the founders considered age and knew how to set age requirements, but placed no such restrictions on the rights, including those protected by the Second Amendment. And so after that argument fails, what the state of Minnesota attempted to do is say, hey, listen, obviously they're 18, 19, or 20 years old, which means they're dangerous and they're irresponsible. And under the Rahimi case, that means we can keep them disarmed because, they're knuckleheads. They're 18, 19, and 20 years old, and they are notorious for being dangerous and irresponsible. And then, of course, what the state does is it just cites to a bunch of generic statistics, bold allegations with no data to support it. So as the Eighth Circuit pointed out, Minnesota's general crime statistics say, according to the report, the murder-arrest rate for 18 to 20-year-olds is almost 33% higher than the murder-arrest rate for the next most homicidal age group. And they are most likely of any age group to use firearms to commit homicides and other violent crimes. But here's the thing. If you allow disarmament based on subjective statistics that could be created literally out of thin air by any governmental agency, and then use that as the crux by which you can disarm individuals, you are now re-injecting back into this equation the balancing test that Bruin removed from this equation. And so as the Eighth Circuit pointed out, a legislature's ability to deem a category of people dangerous based only on belief would subjugate the right to bear arms in public for self-defense to a second-class right subject to an entirely different body of rules than the other Bill of Rights guarantees. Okay, and so ultimately, and this is what the Eighth Circuit has affirmed from the trial court level, and not only is this huge for Minnesota, this is huge for any young person in America age 18, 19, or 20. Because Minnesota is not unique in having these horrific restrictions on the inalienable rights of otherwise law-abiding adults. And what the Eighth Circuit here has ruled is, Minnesota did not proffer an analog that meets the how and why of the carry ban for 18 to 20-year-old Minnesotans. The only proffered evidence that was both not entirely based on one's status as a minor and not entirely removed from burden carrying, Indiana's 1875 statute, is not sufficient to demonstrate that the carry ban is within this nation's historical tradition of firearm regulation. Minnesota has not met its burden to proffer sufficient evidence to rebut the presumption that 18 to 20-year-olds seeking to carry handguns in public for self-defense are protected by the right to keep and bear arms. The carry ban, section 624714, violates the Second Amendment as applied to Minnesota through the 14th Amendment and thus is unconstitutional. Okay, the case once again is Worth v. Jacobson. Remember, the plaintiffs here include the Minnesota Gun Owners Caucus, the Second Amendment Foundation, and the Firearms Policy Coalition, which means that we're putting links for all of them down below so that you can show them some love. Maybe you got some questions about this or anything else related to what's left of our Second Amendment rights. If you guys do, you should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information is down there in the description box. Maybe you got an idea for a video that we should be doing here. If you do, go ahead and click on that link right there. Most of the best ideas we've ever come up with, actually, we didn't come up with at all. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you, in any instance that you may find yourself. From our beautiful Central Washington locations, thanks for watching. Stay safe.